the Education Act, Section 22, School Attendance Orders. Subsection 1. If it appears to the Educational Board for any compulsory education area that the parent of any child of compulsory school age residing in such area is failing to perform the duty imposed on such parent by Section 21, the Educational Board shall serve upon the parent a notice require him, within such time as may be specified in the notice, not being less than 14 days from the service thereof, to satisfy the Educational Board that the child is receiving full-time education suitable to his age and ability and satisfactory to the Educational Board, either by regular attendance at school or otherwise. Okay, so the board, the school board, if they see, or it seems to them that your child is not attending school regularly, they can send you a notice and say, on 14 days after this notice or more, because it says here not less than 14 days, you must satisfy them, maybe in a meeting or some other means, that the child is indeed attending a school, whether it's another school, being homeschooled or so. Alright, let's look at subsection 2. If a parent upon whom a notice is served under this section fails to satisfy the Educational Board in accordance with the requirements of the notice that the child to whom the notice relates is receiving full-time education suitable for his age and ability and satisfactory to the Educational Board, so the parent failed to do so within the time specified, then if in the opinion of the Educational Board it is expedient that he should attend school, the board shall serve upon the parent an order hereinafter referred to as school attendance order. So they send the parent a school attendance order requiring the parent to cause the child to become a registered student at a school named in the order, provided that the Educational Board may at any time at the request of the parent substitute another school for the school named in the order. So they tell the parent to send the child to a school. Subsection 3. If any person upon whom a school attendance order is served fails to comply with the requirements of the order, he shall be guilty of an offense against this section, unless he proves that he is causing the child to whom the order relates to receive, otherwise than at a school, full-time education suitable to his age and ability and satisfactory to the Educational Board. Okay. Subsection 4. If in any proceedings against any person for a failure to comply with a school attendance order, that person is acquitted, the court may direct that the school attendance order shall cease to be in force, but without prejudice to the duty of the Educational Board to take further action. Further action under this section, if at any time the Educational Board is of the opinion that, having regard to any change of circumstances it is expedient to do so, except as provided in subsection 4, a school attendance order made with respect to any child shall, subject to any amendment thereof, which may be made by the educational board, continue in force as long as such child is of compulsory school age, unless such order is revoked by the educational board. Any person who is guilty of an offence against this section shall be liable on summary conviction before a resident magistrate court, in this case of a first conviction, to a fine not exceeding $1. In the case of a second conviction, to a fine not exceeding $4. And in the case of a third conviction or subsequent conviction, to a fine not exceeding $10, or to imprisonment for a term not exceeding 14 days, or to both such fine and such imprisonment. So there you have it. Either 14 days in prison or $1. That's one $1 coin. Or $4. Well, that would have to be 4 $1 coins. Or you could pay $5 and tell them to keep the change out of the kindness of your heart. Or, in the case of a third conviction, $10. So it's either one $10 coin, two $5 coins, or 10 $1 coins. You choose. Section 23, Authorization and Powers of Attendance Orders. Subsection 1, it shall be lawful for any person authorized in that behalf by an educational board, which person is hereinafter referred to as an attendance officer, at any time between the hours of 7 o'clock in the morning and 6 o'clock in the evening on any day, to enter any premises and there, A, make such inquiries as may be necessary to determine whether the provisions of Section 21 or Section 22 are being complied with in relation to any child to whom he has reasonable cause to believe to be residing or employed on such premises. Okay. So, it shall be lawful for any person authorized on behalf of the educational board. So, they can send somebody to search a premises if they suspect that a child who should be in school is being employed on that premises. Right? B, serve on any person a notice under Section 22 or Section 24. Subsection 2, any attendance officer shall be furnished with a certificate of authorization by the educational board for the area concerned, and upon entering any premises as aforesaid, he shall, if required to do so, produce to the occupier his certificate of authorization. 3. Any person who A, assaults or obstructs any attendance officer while such attendance officer is acting pursuant to any power vested in him by this act, or B, having been requested by any attendance officer to give any information of which he may be possessed, as the name, age, resident, parent, employment, or attendance at a school of any child, fails without reasonable cause, or gives such information to the attendance officer, or C, knowingly gives to any such attendance officer any false or misleading information as to the name, age, resident, parent, employment, or attendance at school of any child. So if a child then is not attending a school and they suspect that you or anybody else is keeping the child out of school and employing them, and the attendance officer comes to you, if you try to obstruct the attendance officer from coming on your premises to find out what's happening to the child, or if you refuse to give information about the child or give false or misleading information, let's see what happened to you. You shall be guilty of an offense against this section, notwithstanding that the child in relation to whom such offense is alleged to have been committed is not of compulsory school age, and shall be liable, hold on, guilty of an offense to have been committed is notwithstanding that the child, so even if the child is not of compulsory school age, it seems to be. So you shall be guilty of an offense and shall be liable on summary conviction before a resident magistrate to a fine not exceeding $40. A whopping $40. Alright.